SJC-13053, Jarrett McGilloway, v. Safety Insurance Company.
Great. Attorney McCullough.
Good morning. Thank you, Madam Chief Justice, Associate Justices. May it please the members of the court. I'm Kevin McCullough, and I represent the appellants in this matter. We are here today on direct appellate review following a decision at the trial court allowing a cross motion for summary judgment by the appellees. This case is about damages and remedies available to a tort victim who suffers property damage.
Right. Now, counsel, it's a very interesting case, I think, and I'm going to take a very pedestrian view of it, in that it seems to me your client is hurt, or there's an injury to your client, correct?
A property damage injury, yes.
The property. So this is what I'm getting at. What's the difference between damage and injury? Is there a difference in the legal terms?
I don't believe there is, Judge, especially in regards to the language in the policy as well.
All right. And then if there's no difference between damages and injury, can you talk a little bit about the real estate, the realty versus property issue, the real versus personal property?
Certainly, Judge. The real property is completely different from personal property in that real property is unique. It has unique characteristics, things that can't be replicated if there's damage.
And your point is that the federal court judge did not distinguish between those two things, and I forget the name of the case he had.
And neither did the trial court in this matter, Your Honor.
Okay.
They looked to the restatement, Section 929, which governs and controls real property. And this case is strictly about damage to personal property.
Now, one other question I have is, could your client have sued the person he was in a collision with and obtained a judgment for this inherent diminution of value?
Yes, he could have, and in fact, he still can. This is a matter where all three of the plaintiffs in this case presented damage claims following a motor vehicle collision and received payment for the repair that was done to the vehicle.
Now, what do you say to the argument that we've already gone down this road so far in interpreting the policies to not include this, and that the insurance commissioner hasn't bothered with this area, so therefore we can't do anything now? Well,
the fact that no one has dealt with it, including the insurance commissioner, does not mean that it's not a recovered damage. There are no cases that I'm aware of in Massachusetts that deal with a damage analysis to personal property that follows the restatement second of torts, Section 928. And it's a great question in that the Givens case, which is cited in the appellee's memorandum, is a completely different case. That's a contractual first-party claim where the damages are specifically defined in the policy as far as what someone can recover. And this case is the opposite of that. This is a third-party tort claim where the damages are suffered due to someone else's fault or negligence.
Is it a third-party tort or is it a third-party contractual claim?
It's a third-party claim where the clients, in presenting their claim to the insurance company, become third-party beneficiaries to that contract, to that indemnification agreement.
But we start with the contract provision, right?
I'm sorry, Judge?
We start with it's a standard contract provision, right?
It is.
And is it a contract provision dictated by the Division of Insurance?
It is.
So we've got a standard contractual third-party provision, and in Givens we were interpreting a standard first-party provision. And
Yes,
there's
Judge.
nothing in anything the Division of Insurance has done that suggests that we look at diminution in value, right?
The difference is the damages that are recoverable for the first-party claimant versus the third-party claimant.
Well, but why is that? I'm just trying to make sure I understand why that's different. I understand a third party is different from a first party, but we're both interpreting standard provisions in the Division of Insurance contracts. The Division of Insurance doesn't, right? They've said they don't think it applies to third party as well as first party, right?
They have, based upon...
So we owe them some deference on their own provision, right?
I believe so. I believe so. But I think now is the time to deal with this, Your Honor. This is an issue that's going on. Times are different now. There's damage that follows a motor vehicle collision beyond just the repair. There's damages that follow.
Now you're making a factual argument. I guess I thought your argument was based on the difference in the language of the contract between Part 7, which is limited to direct and accidental damage, versus Part 4, which is what you're pursuing, which are the damages that would be, that the third party would be entitled to if he or she won in a tort case.
That's correct, Your Honor. The damages that a third-party claimant can pursue and potentially recover are much more broad than the damages that a first-party plaintiff can receive suing first party against their own insurance company.
And that's because of the language in the contract.
Yes, Your Honor. Part 4 of the language allows recovery for all damages that would be recoverable.
So your point is that the language of the standard contract is different than the one we were dealing with in Givens, and therefore, because that contract language pegs damages to tort damages, which is to be made whole, that your client is entitled to these inherent diminution in value.
That's exactly the case, Judge. The starting point is the contract, which allows a much more broad array of damages, i.e. those damages in tort. And
Could you parse the particular language for us that you're relying on?
Yeah, as to Part 4?
Yeah, the difference in 4 versus 7 that suggests this broader interpretation, even though the Division of Insurance, which authored this language, doesn't see that difference.
Yeah, looking at Part 4 of the policy, the damages that we will pay are the amounts that person is legally entitled to collect for property damage through a court judgment or settlement. Basically, any damage that could be proven in tort are recoverable. And that includes direct damages, indirect damages, and consequential damages. It's extremely broad, whereas Part 7 of the policy, we will pay the cost to physically repair the auto or any of its parts up to the actual cash value. So under Part 7, the obligations of the insurance company are to fix the car, or if it's a total loss, give you the actual cash value of the vehicle. And in the third-party context, in the tort context, the obligations are to make that individual, that damaged person, whole, which includes putting them in a position that they would have been in but for the accident. So the recoverable damages under Part 4 are much more broad than under Part 7.
I thought you were looking at even more specific language in Part 4 about permits a third party to recover amounts a third party would be entitled to receive against the insured. Isn't that the more specific point that you're making?
Yes, Judge. Any damage that could be recovered by judgment or settlement in pursuit of the insured, the policyholder. And basically, if there are any damages that can be recovered by way of or arising from that incident against the insured, those are all damages that must be paid and indemnified up to the policy limits under the Part 4 of the policy. The Givens court is correct. The decision is correct. It's a first-party claim with a limited analysis and limited damage recovery. This is a different animal. This is a tort claim where...
What do you make of the dicta in Givens that talks about there's just no sign of diminished value recovery in the regulations or anywhere else?
I believe the dicta was talking about how a change in the applicable coverage under Part 7 would have an effect all the way down, which would affect premiums and the cost of insurance. And that's one of the arguments that the appellees make here. They want to make it seem as though if there's a change and it is covered under Part 4, all of these different things are going to happen. That argument was true in the Givens case. In a third-party claim, if the court allows recovery of diminished value under Part 4, it's not going to affect or change premiums. The premium under Part 4 for damages...
That makes no sense to me. Why wouldn't it have this exact same effect? Because you're paying out third-party claims as well as first-party claims, so when... I don't get that.
I can answer that, Judge. Under Part 7, the factors that impact the amount of the premium charged include garaging, who's driving the vehicle, the year, make, and model of the vehicle, the driving experience of the driver, and they know when they write that policy
But if
what
they
their
have to-
exposure is on the vehicle.
But if they have to pay diminished value, in addition, it's just going to raise the cost of insurance, right?
I don't see that it will, Judge, because under Part 4, the liability insurance, when that policy is written, it's based on two factors: the driving history of the insured and the amount of policy limits that they select.
But counsel, I'd suggest to you that that's just not right, right? I mean, premiums are set based on how much the insurance company expects to pay out. And if we determine that inherent diminished value is something that they need to pay out to third parties, they're going to pass that along to the insured. So I don't understand this argument and suggest maybe that's not your strongest. Your strongest seems to be that the standard policy language is different in Part 7 than it is in Part 4. And to interpret it to be the same, despite the difference in language, seems wrong under our canons of construction.
Judge, I agree with that. I was trying to answer a question on how it may impact the insurance.
Well, and counsel, whether it impacts the premiums or not, the whole point of insurance is to spread these risks, right?
That's correct, Your
So and that doesn't necessarily concern us right now in the interpretation of what's the policy and our case law. Is that correct?
It doesn't.
So let me ask you one question. There's a reference in one of the briefs to an advisory opinion from the Division of Insurance saying that there's no coverage under a standard policy for inherent diminished value. Or do you know, I can't remember what year that was. Do you know the year?
I believe it was after Given. I don't,
Okay, so that wasn't that, but was it before Carfax? I guess that's my question.
I don't believe so, Your Honor.
So, okay, so, because I think, isn't it really that something like Carfax has come in and changed everything now?
That's correct. That's
Okay.
correct. As mentioned by the court,
Well,
the
has it
strength.
changed it or just provided more solid documentation to determine where there's diminished value? There's always, this is not a new concept, right? This has been around forever that.
It is not a new concept, and in fact, many states, looking at the restatement, Section 928, allow for the recovery of the repair damages as well as that loss in value. And let's be clear, not every vehicle that's involved in a collision suffers diminished value damages. That's not the plaintiff's position. But it's something that can be assessed according to the defendant's testimony during the pendency of this case, that when they do the appraisal, they have everything they need to determine if there is diminished value and assess what that diminished value is. I want to talk about one point where the appellees say that 928 shouldn't be followed, but even if it is, that with due allowance language only applies when there's a betterment. Now, a betterment is a concept where if an older vehicle gets into an accident and they get new parts and some fresh paint, it may be worth more money. We believe in that. Betterments are true, they happen. But the insurance company can quickly and easily calculate that betterment in that situation and recoup that money to the extent that it made the vehicle better. We're just looking for the same thing on the other side of that. The vehicles that are newer, that suffer damage and get repaired, they're worth less money. Those claimants and those consumers are entitled to be paid those damages to the extent that their vehicle was reduced in value because of the collision. The argument that the appellees made is literally the argument that we're making through 928. It just cuts both ways. They just can't pick one side of it and say we don't want to use it on the other side to the extent that it hurts us. It's a very important point because they can calculate these damages quickly and easily at the time of the appraisal. The damages exist, and is it covered under the policy? And when you look at Part 4 of the policy and the breadth of those tort damages, it is covered because it's an item of damage that can be recovered by way of judgment or settlement. One other point I want to quickly make is this concept of being made whole. When we can calculate a damage and we know that it's there and we know that it's real, you're not fully paying the consumer the true value of that incident or that vehicle. And the principles that we follow here in Massachusetts, that made whole doctrine, is extremely important. And when we look at the made whole doctrine in conjunction with the restatement second of tort, section 928, personal property. That's where the case went sidetracked, Your Honors, in the federal court and in the district court. All of the cases cited were in regards to land transactions or damage to land, some of them even with oil and under the 21E Act. This case is different. It's a recognized damage. It can be quantified, and it should be covered under the policy. Thank you.
Thank you. Okay, Mr. Apjohn.
May it please the court, my name is Nelson Apjohn. I'm appearing today on behalf of the Commerce Insurance Company. And with the court's permission, Attorney Bossy, who is here from Safety Insurance, and I will split the argument time. I'll be addressing the lack of coverage under Part 4 of the policy, and Attorney Bossy will address Massachusetts tort law in regard to inherent diminished value claims. The issue before the court with respect to the policy is whether a third-party claimant is in any better position or has any greater right to recover on an alleged inherent diminished value claim than the policyholder in Given. And the answer to that question is no, in large part for the same reasons expressed in Given. Although Given was a first-party coverage claim, the court in Given covered in detail the regulatory scheme in Massachusetts with respect to denying the claim of that first-party claimant. In that review of the statutory and regulatory background.
Counsel, can I ask you a question? Why does Part 4 use different language in Part 7, and what do we do with that?
Well, it's different language because the language comes in part from the statute, which is Chapter 90, Section 34O, which says in a Massachusetts motor vehicle insurance policy, it has to have provisions for property damage. That provision also states, however, that those provisions are subject to the conditions, exclusions, and limitations approved by the commissioner. And one thing that's been left out here that was stressed and given is that the policy has to be construed consistent with the regulatory and statutory background of automobile insurance in Massachusetts. What also has been left out when we talk about the policy language, as the Given court noted, the policy expressly incorporates by reference the statutory and regulatory provisions. They become part of the policy in Massachusetts.
So we have a canon of construction which says something to the effect of every word means something. And when you use different words in Part 7 versus Part 4, I'm struck by that. In Part 4, there's the language that says that the damages are measured by what the person is legally entitled to collect for property damage through a court judgment, which we know is to be made whole.
Yeah.
Whereas Part 7 specifically limits the first party to direct and accidental damage. I'm still struggling with why those two things mean the same thing.
I think, Your Honor, because one of the things Given also said that when you look at inherent diminished value, you have to look at it in the context of what the policy covers. And as I said, that policy incorporates two regs, which I would like to discuss this morning, that are directly applicable here. So you have to read the policy with the regulatory background there. It's not a question, as the court points out, whether inherent diminished value might be a means of recovery in some other provision. And I think even with tort claims, because we're dealing with mandatory insurance, and the commissioner is given the right to make exclusions, limitations, and conditions, the commissioner controls the scope of that coverage within the policy. As Justice Kafka mentioned, the court in Given says you can search that regulatory background and the statutory background, which is described as a vast network, in vain for any reference to any concept dealing with inherent diminished value. It doesn't tell you the methodology for
It may not tell you that, counsel, but I'm still struggling I wanted to wait to this side to ask this question, but if you go back to what Justice Cipher said at the beginning, you don't disagree that the injured party here could file a tort action against the insured to recover that diminished value. You don't contest that, right?
Agree, and Attorney Bossy will say Massachusetts tort law does not recognize a claim of inherent diminished value where the repair costs have been paid.
No, but so you're saying that deficiency that they would just be stuck?
I think what I'm saying, Your Honor, is you have to read this in context, and let me just talk about two regulations that I think directly apply. The first is 211 CMR 133, which by its terms applies to both first and third party claims and deals with the standards for repair of damaged motor vehicles. The second is.
But counsel, I don't mean to interrupt, but wouldn't the real issue be whether the claimant had settled the case and had signed off other rights rather than what the regulations don't say that they can't sue for the difference
Right.
or the inherent diminution in value, but they only couldn't sue if they had settled, officially settled and waived all claims,
No,
couldn't they?
I guess I would not agree with that first premise, Your Honor, is that, this is mandatory coverage in Massachusetts, all right? And 211 CMR 133 states that it applies to all motor vehicles insured in the Commonwealth and only when an insurer pays for the cost of repairs. And the claimant expressly applies to third-party claims. I think with respect to the mandatory insurance in Massachusetts, the commissioner is given basically the responsibility to balance the scope of coverage and the cost of coverage. And that's what's done here. If you look at 133, as Judge Sanders recognized in Ramirez versus Commerce, which was affirmed on appeal, 133 is a cost containment regulation. And what that does is that the insurer can consider a vehicle to be a total loss where the repair cost and estimated salvage value is more than the actual cash value of the vehicle. In short, the insurer does not have to pay more to repair the car than the car is worth. And that was, in substance, one of the policy provisions in Gibbon that the court looked at, actual cash value as a cost containment. That's a cap on what the insurer has to pay. In substance, if you look at what the plaintiff is asking here is to go beyond the regulations. You're defeating the entire regulatory cost containment scheme that the commissioner has come up, balancing the scope of coverage with the cost of mandatory coverage. This is not coverage an insurer can say, this is too expensive, I'm going without it.
I'm still struggling with this because it seems to be that you're comparing apples to oranges. You have a situation where the cost containment is pretty clear, where the vehicle is so damaged that to repair it's going to exceed the actual cash value of it. So it just doesn't make any sense. So from a cost containment perspective, that's okay. But when you have a situation where we're talking about here, where the vehicle can be repaired, nevertheless, even once it's repaired, the person who did nothing wrong has a vehicle that's worth less than before the accident happened that was your client's fault. So how could we reconcile the common sense provisions in the difference between 4 and 7 to say we are going to sanction that the regulations allow someone who did nothing wrong to walk away worse off than they were before the accident?
That's the balance I'm talking about, Your Honor, with respect to what the commissioner does here, he in this situation, as a balance. What is the scope of coverage for this mandatory insurance, and what is the cost? How do I control those costs? This particular claim is a perfect example of what I'm talking about, because Commerce paid approximately $6,700 to repair the car. Months later, the whole process is done at that point. Months later, Mr. Ercolini comes back and says, my car has an alleged report. My car was worth $10,000, and I have an insurance, an inherent diminished value claim of $4,450. If Commerce were to pay that, they would have paid in total over $11,000 more than the car is worth. The regulations do not contemplate a situation like this. And that's why I think the commissioner, especially when you're dealing with mandatory insurance, where they have to weigh the balance of cost and coverage, it's particularly appropriate to defer to the commissioner in that situation. It's very like the.
But from a cost containment perspective, what do you say to your brother that says, but you can calculate that at the time that the vehicle's being appraised?
I think that's entirely wrong. There's nothing in the record to support that fact. We had experts debating it. NADA, which has been around a lot more than Carfax and is a recognized valuation guide, as we put in our addendum, says they don't take any stand on inherent diminished value because it's very difficult, if not impossible, to value in regard to a car. So this concept that you can just look at various car values and come up with the appraisal there is wrong. The car hasn't even been repaired yet. How could you tell the difference? There's nothing you can look at as a guide and just say, here's the difference in IDV. You'd have experts going back and forth in an adversary proceeding debating what the actual cash value is. That's why the regs simply don't contemplate that.
Are there any other questions?
Is that just on that last point, is that in the record? Because that seems important to me. If inherent diminished value is something that cannot be calculated definitely.
There is certainly.
Where is that in the record?
It's certainly a material dispute. In the record, first of all, with respect to NADA, we quote NADA there from their website. Our experts said, with respect to Mr. Riccoloni's car, it was worth the same, if not more, when you look at the new bumper that was put on the car, the paint job. That car had 98,000 miles at the time. There's certainly not inherent diminished value across the board. In fact, that was the claim in the Superior Court. Every time a car was in an accident, you have inherent diminished value. There's no way you can just simply look up in a book and come up with an inherent diminished value claim. What you're going to do is go to an adversary system where instead of going to your own insurance company with a collision claim where you don't have to battle anybody, but you can't recover IDV under given, you're going to start an adversary claim against the third-party claimant or against the third party and their insurer. So this is not only a monkey wrench in the system, but this would be blowing up the regulatory scheme that the commissioner has come up with to balance the cost and scope of coverage for mandatory insurance. Again, this is not something that the insured can refuse, and the commissioner is entrusted with controlling the cost, which he does in 211 CMR 133, as well as.
I think that gives me my answer. Thank you.
Okay, thank you very much.
Thank you, Your Honor.
I'll let you gather your things and let Attorney Bossy step up.
Thank you, Your Honors. My name is Peter Bossy, and I represent safety here. And one of the things that Mr. Apjohn indicated is that I'm going to be addressing an issue that actually appears to have been leapfrogged here already with respect to the discussion that's been going on.
Okay, can I interrupt you first? I have one question specifically for safety that might not be relevant to this. I read in the briefs that safety adjusts and makes payments to third-party IDV claimants and treats that as covered when somebody makes a specific demand for that. Is that accurate?
Your Honor, in the scope of this case, in the scope of the context of handling claims, they had to come up with a way to handle claims that came in. That's not inaccurate as far as handling claims. That doesn't necessarily mean that it's actually covered under Massachusetts law or even covered under the policy. Insurance companies
But it does suggest that it's measurable. Whatever safety's using as a measure by definition, it's measurable then.
Your Honor,
that might not be the only metric, but at least there is a metric.
Your Honor, faced with situations that they're required to do pursuant to various guidelines and 93A, 176D, things of that nature, they have to settle cases. Just because they settle it, they make a best opportunity or best chance to take a look at how they would actually settle that case, if in fact it can be. But here I think we have leapfrog this whole idea about whether or not mass common law even allows for the recovery of these so-called inherent diminished values. This is a change, and if you look at the Martins Court, they specifically talk about that in the federal court. There is nothing under Massachusetts case law to support a measure of damages for inherent diminished value. And what's important here is
Why
that,
counsel does not fall under the made whole argument?
Your Honor, the whole idea of being made whole, in Massachusetts, we make people whole by this whole idea of the measure of damage being the cost of repair versus diminished value. They're mutually exclusive. That's the case law. And what my brother wants you to do, and that's the case law that we have case law that deals with both, it deals with real property. But now you're going to be you're going to have a difference somehow as to real property versus personal property. And that really doesn't make much sense. And that's what the Martins Court struggled with.
Well, but counsel, with Martin, wasn't there somewhere I read, and again, my memory's failing me here, that note that it says it doesn't support that, but that and they cited to the mass practice, but then when the cases are examined in the mass practice for support of that, they don't support that proposition at all.
They don't support the proposition that there is
a difference between the real property, no difference in treatment.
Well, Your Honor, I agree. And look, if you look at the cases that are discussed here, whether they be Belkis and Black, they're all situations where the real property, there has either been a cost to repair, where the property has been restored to its prior condition as a result of these reasonably curable repairs. And I suggest to you that's what we have here. Reasonably curable repairs. It's not perfect, but it's reasonably curable repairs versus diminished value, the fair market value before and afterwards. Here, what they're asking you to do is they're asking you to, in this inherent diminished value world, they're asking you to actually give a further recovery here, okay? A further recovery that hasn't been allowed at all in Massachusetts. This inherent diminished value, it's so-called stigma damages. It has not been allowed. You don't have that. In cases, there is a case that my brother brought up in Bisson. Now, the Bisson case does talk about the fact that there was, in that circumstance, the property was, they were allowed to recover diminishing values. Because why? Because the property damages weren't reasonably curable, okay? It wasn't enough.
Now, counsel, but the sky is falling kind of argument, there are other jurisdictions that recognize these damages, right?
Well, Your Honor, that's true.
No, but,
okay?
but let's just focus on that for a second, because there are other jurisdictions that recognize this recovery that have somehow figured out a way to measure them and have somehow the entire automobile coverage policies in those states haven't fallen apart. Why would this be such... You make it sound as if this would be such a bit of a unicorn for the court to recognize these types when other jurisdictions do it all the time.
Your Honor, it's not all other jurisdictions. As we pointed out in our brief, New York, there's some appellate court in New York that doesn't allow for it either. But here, and it goes back to the regulations here, this is a heavily regulated state. There is no indication from these other jurisdictions at all in the record as far as how those programs actually work out. This state is heavily regulated with respect to, under the policy and under from the commissioner as to how to deal with these damages. And so that's the difference, I think. Okay, and there is no indication in the record that of what these other programs in place at these various states actually allow for.
Sure. Our case law has said that we will give deference to the regulations. They've never said that they were conclusive. So it could very well be that the regulations interpretations of the differences between 4 and 7 are wrong. And we might conclude that they're wrong. So tell me if we were to conclude that perhaps the interpretation of the different the different policy languages in 4 and 7, that their interpretation is wrong.
Well, Your Honor, I want to go back to one thing, and this goes away from where I was primarily speaking about, but in this context, in the third-party property damage world, okay, the language that we're talking about actually deals with 34O, and that's damages because of property damage. And that's important here, okay? Because these are not damages. These inherent diminished value damages are not damages
Are they an
because of
injury?
property damage.
Are they an injury?
I don't think in this case they are, Your Honor. I think there can be a situation where diminished value, as the court has pointed out, when there's a situation where the property damage cannot be reasonably curable, you could have diminished values in addition. But not in this case, not where the whole premise here, Your Honor, is that these damages, this car is completely repaired. There are no problems with this car at all, and either one of these cars. So going back to the argument about
Can I ask, if it's a jump ball, because the thing is not as clear as it could be. If this is a jump ball, do you win on administrative deference? Or, I mean, we've got a mandatory term, we've got, so no, we don't read it against you, right, in this context. Normally we read, if you wrote the insurance policies, we read against you, but this is a mandatory term, right? It's not that clearly written. Do we have express interpretive guidance from the Commission of Insurance that this provision does not provide for the diminished value? Or is it just that what Givens talks about, an absence of discussion?
I think it's in absence of discussion, but that being said, I want to go back and point out, this whole damages argument is extremely important, because when you go to what they are so-called legally entitled to recover, and the but-for argument, these damages are not damages because of property damage. And I think that's extremely important to point out here.
What are they
They're not-
damages
understand that.
because of?
That makes no sense.
I'm sorry, what?
I don't understand that.
Because essentially, Your Honor, these are the so-called property damages here, okay, are repaired. The
No, but
property
that
damage is
assumes
actual
the answer
damage
to the
vehicle.
question. The question is, I have a car, your client crashed into it, the language says you make me whole because it adopts the tort law. Why, if I had a car that was worth $20,000 before the accident and now it's worth $10,000, even though you repaired it, why am I suddenly whole, even though I'm in the hole,
Right.
by $10,000?
Well, Your Honor, I guess if the court wants to change the law.
No, I don't
okay,
want to change the law. I'm
right now,
asking for
because
your
in first-
position on the contract language that was adopted specifically.
The contract language talks about in models after 34O. 34O affords coverage for damages because of injury or destruction to property caused by an accident. In this case, these damages are not related to actual physical damage to the vehicle. The
But that's
physical
it. So
damage
now
is
you're
gonna-
adding that language. There's nothing in there about physical, is there? I didn't hear it.
Well, in terms, it's caused by, and that's the whole question about whether or not it's caused by the actual damage. And caused by is considered more of a narrow term than so-called arising out of. And that's the statute. The statute talks about damages caused by, not damages arising out of.
Can I
And it
ask-
also adds.
Can I ask one last question, because we're going to lose you? We're going to have our law clerks do their lovely 50-state review on the unicorn question. When we do that review, what are we going to find out there? Do most states allow this diminished value, or do very few? What's the sort of, because
No, I think you're going to find that more than not. We've cited in New York,
more than not do what?
more than not allow for this.
Okay.
Thank you very much.
Thank you.
Thank you.